Hi, my name is Diana. Thank you so much for joining our webinar. SunRay secures $10 billion annually for GC subs and suppliers. We're a national construction document service. Today's webinar is conducted by the wonderful Kevin Estevez, an Arizona construction lien law expert. Today's webinar topic is a contractor, subcontractors, and suppliers step-by-step guide to getting paid. Without further ado, I would like to introduce the fabulous Kevin Estevez.
Thank you, Diana. I appreciate it. As Diana said, we are here to talk about a contractor, subcontractors, and suppliers step-by-step guide to getting paid. I appreciate the wonderful introduction. I will make a caveat. Arizona, in some respects, designates attorneys as certified experts in areas. And while I do practice in construction and have my career, I'm not a designated expert. But with that, let's jump in. Welcome to the webinar. If you have any questions, use the GoToWebinar chat box on the right. We will answer questions at the end. Please do not include names, company names in the question. We're talking today about contractors and subcontractors and suppliers, steps they'll take to get paid on a project and for work they do. And we're going to go over several steps here today. And those steps assume a couple things. The first thing is in Arizona, it is number one, it's unlawful, and number two, it precludes your right to get paid if you're not a properly licensed contractor. So with contractors and subcontractors, the first step you need to comply with to get paid is making sure you're a licensed contractor and making sure you have the right license for the work that's being performed. Because without that, Arizona law is very clear that is a bar to getting in court and suing to recover monies you may be owed. So that's step number one, and the steps we're going to talk about assume that that was taken care of. Number two is enter into a contract, review the contract that you may be presented on a project, and make sure you understand its payment terms and make sure that it has favorable payment terms to the extent you can negotiate those. So, you know, what we're going to talk about today, our steps pick up right where those things leave off and assume that, number one, the contractor supplier is properly licensed, and number two, they have taken the time to enter into a contract, negotiate that contract, and so on and so forth. And the reason I don't get into the contractual issues so much in this webinar is because it's gonna depend. It's, you know, contracts are negotiated differently, and they may have different terms, and so it's impossible to cover all the scenarios. But I will, you know, suggest that folks do take time when entering into contracts, consult with a qualified attorney to go over the terms of a contract and negotiate a contract. And then once we get there, and once you start performing work on project, if in the unfortunate circumstance you're not getting paid, Arizona law, thankfully, provides contractors, subcontractors, and suppliers who furnish labor or materials to Arizona construction projects various remedies to collect sums that they may be owed. And Arizona, like most places, has robust remedies for contractors, subcontractors, and suppliers, because the law recognizes that in many respects, these folks are extending credit on construction projects to get the project going. Once a project is started, you know, the suppliers that furnish material or the subcontractors that start work, they're gonna, you know, be paying money out of their pocket to get the project going, and until, you know, they submit their first pay application or invoice, they are essentially the ones funding the project. So the law recognizes that and protects their right to be paid. And two of the most effective remedies that Arizona law provides for contractors, subcontractors, and suppliers are mechanics liens and payment bond claims. And in most situations, contractors and suppliers must timely serve a proper preliminary 20-day notice to preserve these claims. And we'll talk about what that entails in terms of serving that 20-day notice, what the 20-day notice should look like, and in what circumstances that must be done. And I will just say the caveat is that in most circumstances in Arizona, you want to serve a preliminary 20-day notice if you're furnishing labor and materials to a project. And so that's one thing to take away from today's webinar. Is that if you're not doing so already, you want to make sure you're sending out preliminary 20-day notice on a regular basis. And then Arizona also has a robust prompt pay statute. Actually, it has multiple prompt pay statutes that we'll talk about. Arizona law provides for a prompt pay act that governs private projects, and separate prompt pay acts that govern public projects. So a lot to talk about here. And of course, when we're getting into these things, what I'm going to talk about today is in addition to breach of contract claims that contractors, subs, and suppliers may have, and it also is in addition to other potential avenues of recourse that subcontractors and suppliers particularly may have on projects, and the Arizona Register of Contractors permits no pay complaints to be filed. So that's another avenue that folks can go down to get paid if they're not getting paid on a project. So with that, let's talk about step one of our steps and our step-by-step guide to getting paid, and that is, as I mentioned on the previous slide, to serve a preliminary 20-day notice. In Arizona, with the exception of laborers for wages, every lien claimant and some Little Miller Act bond claimants must serve a preliminary 20-day notice. And what happens is if you do not serve a 20-day notice, you forfeit all your lien rights. And if you do not serve a timely 20-day notice, you forfeit a portion of your lien rights. And I'll get into that in a couple slides. But with respect to lien claims, if you're working on a private project and you want to preserve your lien rights, you got to serve a preliminary 20-day notice. And not all Little Miller Act bond claims in Arizona will require those who are asserting a claim to furnish a 20-day notice, but it certainly doesn't hurt. And there are certain circumstances where certain claimants will have to have served a preliminary 20-day notice prior to asserting a claim. And so what is a 20-day notice, and why is it done? As the bottom of the slide shows, this is a case from Damastro v. Els, Damastro and Els, v. Taco Bell. And the idea behind a 20-day notice is to give the owner and others affiliated with the project advance notice that there's someone out there performing work that expects to be paid. So what does a 20-day notice look like? What's it supposed to include? In Arizona, our preliminary 20-day notice must contain the following information. 1, a description of the labor and materials that will be furnished and an estimate of the total price thereof. 2, the name and address of the person furnishing the labor and materials. 3, the name of the person who contracted for the purchase of labor or materials. And 4, an adequate description of the job site for identification. And 5, a specific statutory notice to property owner that's set forth in ARS 33-992-01C5. So that's the required contents of a preliminary 20-day notice, and the Arizona legislature has thankfully provided a sample preliminary 20-day notice that's in the statute, and the forms, the notices sent in Arizona must substantially follow that sample. So again, it's important to get your 20-day notices out, and then they must be served. And they must be served on the owner or the reputed owner, the original contractor or reputed contractor, the construction lender or reputed construction lender, and the person with whom the claimant contracted. They should be addressed to the recipients at their address or business address and served via either, number one, first-class mail with a certificate of mailing, or 2, registered or certified mail with postage prepaid. And the old mailbox rule, that is a long established legal principle, applies with respect to 20-day notices in Arizona. And that is to say that 20-day notices are deemed served when they are deposited in the mail. Serving a 20-day notice. We talked briefly about who it must be served on. Now, equally as important is the timing of the service of a preliminary 20-day notice. And I said at the beginning, when we first started talking about notices, that if you don't serve one, you forfeit all of your lien rights. And if you serve one in an untimely fashion, you forfeit a portion of your lien rights. And here is the explanation behind that comment. So it's best practice to serve a preliminary 20-day notice right when you start performing work on a project. And that's because under Arizona law, a 20-day notice will reach back 20 days. So if you serve one when you start work on a project and it's statutorily compliant, you have the right amount in the estimated total that's required, it will cover you going forward on the project. If you serve a 20-day notice late, you can still do it, and the law allows for it, but you're not going to have lien rights for all the labor and materials furnished. And the example I give here on the bottom is illustrative of this situation. So if a subcontractor first furnishes labor and materials to a commercial project on March 1st, but neglects to serve a 20-day notice until March 30th, it will only have lien rights for the materials furnished on or after March 10th. And that's because the 20-day notice reaches back 20 days. And so the notice is served on March 30th, which is 30 days after work or materials were furnished to a project. And so March 30th goes back to March 10th, and anything from March 10th going forward will be covered, provided the amount's correct, and so on and so forth. But that time period that you have from March 1st through March 10th will not be covered because there wasn't a timely preliminary 20-day notice. And so, a lot of times folks will wait until there's a payment dispute on a project to start worrying about a 20-day notice. And if you do that, you may have waived your right to record a lien for a significant portion of the amounts that are the subject of that payment dispute. So step 2. Step 1 is serve a preliminary 20-day notice. Step 2 is to know your rights under Arizona's Prompt Pay Acts. As I said at the outset, Arizona has both private and public sector prompt pay laws. ARS 286924 applies to ADOT projects. ARS 412577 applies to state projects, and ARS 34221 applies to other government projects. And these are the prompt pay laws that govern public construction projects. Arizona's private sector prompt pay law can be found in ARS 321181 at SEC, and it governs private construction projects lasting more than 60 days, with the following exception. So Arizona's private sector prompt pay laws, there is a caveat with respect to residential which is a general term, but the way the statute defines is owner-occupied projects. It only applies if the contract with or invoices to an owner occupant contain a notice that the prompt pay law applies. And then Arizona law does allow parties on private projects to amend the prompt pay structure, but you have to do so in a specific way, and there's certain things that need to be done. First, the prime contract needs to provide for a different payment schedule in a clear and conspicuous manner. And two, a statutory notice of alternate billing cycle needs to be placed on every page of the construction and bid plans. So and the reason that's done is because folks downstream, especially those who do work regularly in Arizona, expect Arizona's prompt pay laws to apply, and without some sort of notice that the project has deviated from the prompt pay structure, those folks may not their expectations may conflict with what's really happening on the project, and they may not have been properly informed. So the idea is that if the statutory notice of alternate billing cycle is posted on every page of the plans, especially the bid plans, the folks that are bidding on the project, the subcontractors that may be significantly downstream, will be alerted when they look at their portion of the plans that the project is following an alternate billing cycle. So in order to basically opt out of Arizona's prompt pay laws on a private sector project that lasts more than 60 days, it can be done, but it is onerous, and it's onerous for a reason. So standard billing cycle on public projects, both prompt pay statutes are basically structured around a 30-day billing cycle. On public projects, the structure is set up where the owner receives the general contractor's invoice. They have 7 days to approve it and 14 days to pay. And then the general pays subs 7 days after receipt, and then the subs pay suppliers 7 days after receipt. This is next the standard billing cycle on private projects, and so it is very similar to the public structure or the public structured prompt pay laws with one important difference, and that is that on private projects, the owner receives the invoice from the general contractor, has 14 days to approve it, and then 7 days to pay. So the time to approve and pay is flipped on public versus private sector under Arizona's private versus public sector prompt pay laws. Then, as with the public sector prompt pay laws, the general has 7 days to pay, and then the subs have 7 days to pay suppliers. So focusing on the private sector prompt pay laws now, because that's the one that most folks typically encounter. Like I said before, we have a standard 30-day billing cycle that the law essentially provides for. Owner has 14 days to approve the general's pay application and 7 days thereafter to pay. Contractors and subcontractors pay their suppliers within 7 days after receiving payment. And then, if an owner and or contractor disputes the work that's being billed by those downstream, they should object in writing, and there's certain mechanisms for that. The 14-day time period from the owner to the general contractor objecting to an invoice, or it's deemed certified and approved if the owner doesn't object within 14 days of receiving. And then the prompt pay law also affords some protections to contractors. and subcontractors, and it provides that that they can suspend and or terminate performance if they're not timely paid, and if they provide sufficient written notice to upstream parties within certain timeframes set forth in the statute. Also, the Prompt Pay Act provides for a more significant rate of interest on sums that are due than you would typically otherwise get under Arizona law. Interest accrues at 18% per annum, and that's another benefit of the prompt pay laws, is that to the extent a contractor and or subcontractor has prompt pay claims, those will accrue interest at 18% per annum. One thing I'll mention here, and it's it could be the subject of an entire separate webinar, and something you see rather frequently in construction contracts now, is pay if paid clauses. There is an Arizona case, L. Harvey Concrete, that says that pay if paid clauses can be enforceable in Arizona in certain circumstances. There is some debate within those in the construction legal field about how those mesh with Arizona's Prompt Pay Act, but that issue has not been decided. At the time that L. Harvey was decided, Arizona's prompt pay laws were in effect, but the issue of whether or not the pay if paid provision conflicted with L. Harvey was not addressed by the court. So there's debate on that issue, and I just bring that up because those folks who are familiar with the way construction contracts are typically drafted in Arizona will be familiar with pay if paid provisions, and that they'll have seen those. So that's something to certainly talk to an attorney about if you see one of those types of provisions in your contract. So with that, let's move on to step 3, and that's document change orders and supplement preliminary 20-day notices if necessary. So one of the requirements of the context of preliminary 20-day notice is an estimate of the total price of the labor or materials to be furnished on a project. You don't have to get it exactly right under Arizona's statutory scheme, and that's because the law affords contractors and suppliers some wiggle room. So if let's do it this way, a lien is limited to 130% of the estimate amount in a 20-day notice. So if you have a contract for $100,000, day one of the project, you issue preliminary 20-day notice for the $100,000. You are protected up to $130,000. So you get 130% of the total estimate is the amount that you can, amount of lien rights you have on that project. What happens in a situation where you get a change order for initial contracts 100,000, you get a change order for 50,000. So now the total amount of the labor and materials to be furnished is $150,000. So now you've exceeded that 130% threshold. What do you have to do in that circumstance? You need to supplement your 20-day notice, and you supplement your 20-day notice within 20 days of furnishing the additional labor or materials. So you want to make sure that you're on top of that as change orders come in. You're keeping tabs on, okay, here's the total amount of lien rights I have on a project. I'm getting these change orders coming in. When do we get past that 130% threshold? And when you do that, when you get past that, and you want to serve a 20-day notice within 20 days of furnishing the work that takes you over that threshold. And two important points on this is, number one, I'm sure I'm preaching to the choir here in terms of those in the construction industry, and I'm sure the folks have run into this a lot. But a lot of times, payment disputes arise out of issues related to change orders, and specifically not documenting change orders. Part of this step 3 is you not only got to supplement your preliminary 20-day notice, but you want to make sure that you're documenting your change orders. You want to make sure that you're getting written confirmation of what the work's supposed to be done, the price that's going to be paid, the amount that is increased, the time, the amount of time that it is being increased. You want to have all those things memorialized in a written change order document. And you want to have that signed by both parties, and you want to make sure you have that so when there's an issue of you not receiving payment, you can go back and you have documentation establishing what the agreement was with respect to the change work. So that's step 1, document the change work. With respect to the notices and the supplementation of preliminary 20-day notices, you can see this done incorrectly a lot, and it's a situation where the initial contract was $100,000, you have a $50,000 change order, and so the initial preliminary 20 notice was for $100,000, and then the estimate of the total price in the supplement is for only $50,000, and that's incorrect. So it should not be a supplement with just the amount of the additional labor. The supplemental 20-day notice should include the aggregate amount of the estimate of the total price for the project. So in our example, the new 20-day notice would have a estimate total price of $150,000. Folks get into problems when they do a supplemental notice. So make sure as you're supplementing, you're always thinking about the aggregate total price. So that's step 3. Step 4, know your deadline to record a mechanics lien or make a payment bond claim. On private projects, mechanics liens assert an ownership interest in the real estate on grounds that the claimant provided services or materials to improve the property and has not been paid. Liens cannot be recorded on public property. An owner-occupied residence cannot be liened unless the contractor or supplier has a direct contract with the owner. And that's an important one and a hang-up that sometimes a lot of folks miss who do residential work. Unless you have a contract with the owner-occupant, you don't have lien rights. So subs on residential work, if it's an owner-occupied, you're not going to have lien rights unless you have a separate agreement. And then if the project is being built for a tenant improvement, a contractor or supplier may only have lien rights against the tenant improvements or the leasehold interest in the property, and may not have lien rights against the underlying parcel. And that depends on certain circumstances. So if you're in that situation, I would suggest that you consult with a qualified attorney. So because public property can't be liened as set forth above, federal and state law require payment bonds on projects of certain type and size. And qualified subcontractors and materialmen may have claims against these bonds if they satisfy certain notice requirements. So let's jump into that. First of all, when must you record a lien? In Arizona, in almost every circumstance, and we'll talk about the exception, a lien must be recorded within 120 days after project completion. And that is the entire project completion. So if you are a excavating contractor that's out there at the beginning of the project, or you're a finished carpenter who's out there at the end, both of your time to record a lien runs from completion of the entire project, and that's different on payment bond claims. And so I want to make that distinction. What is completion for purposes of Arizona law? Well, completion, it usually occurs 30 days after a certificate of occupancy is issued. So completion occurs 30 days after that certificate is issued, and then you have 121 days after project completion. So in that scenario, you have 150 days to record your lien on the project. If, however, no certificate of occupancy will be issued, completion occurs on the last day when any labor or materials were furnished. So you have 120 days from completion in that scenario. If work stops or is abandoned for 60 days and the stoppage is not due to an act of God, completion is 60 days after that stoppage of work. And so that means that you have a total of 180 days to record your lien. So it's a little bit confusing, but the idea is that you have completion, and completion can be defined in certain different ways depending on how the project's going. But you have 120 days after you get to completion to record your lien. And that is the case in every circumstance but one, and that's if an owner records a notice of completion. And a notice of completion is a statutory document that shortens the time within which contractors or subcontractors or suppliers must record a lien. And the notice of completion, it shortens that to 60 days. But for a notice of completion to be operative, as it says here on the slide, it must be served on those who served a preliminary 20-day notice, and it must be recorded in the county where the project is located. So with absent the service of and recording of a notice of completion, time to record a lien is 120 days after project is completed. What happens after the lien is recorded? And the first step is you got to serve your lien. Arizona law provides that lien claimants are obligated to serve a copy of their notice and claim a lien on the property owners within a reasonable time of recording. The term serve requires that service be made by mail, first class mail, registered or certified, with sender obtaining a certificate of mailing, receipt of registration, or receipt of certification. But it can also be served in the same manner that process is served in connection with lawsuits. And the phrase "a reasonable time after recording" is not defined in Arizona law. But with that being said, you want to serve your notice and claim a lien as promptly as possible. Payment bond claims, and then we'll be wrapping up here shortly. So on public projects, you don't have lien rights, and in those circumstances, general contractors, in most cases, are required to post payment bonds and performance bonds as well. But payment bonds are what we're talking about here today. And under the Federal Miller Act and Arizona's Little Miller Act, there are certain notice requirements you have to comply with to assert a claim on the bond. And under the Miller Act, laborers and materialmen with no direct relationship to the general contractor furnishing the payment bond, they must give written notice to the contractor within 90 days from the date on which the person did or performed the last of the labor, or furnished or supplied the last of the material for which the claim is made. Under Arizona's Little Miller Act, there's that 90-day notice, but there's also a requirement on the front end to issue a preliminary 20-day notice. So any claimant who has a direct contractual relationship with a subcontractor of the contractor furnishing the payment bond, but not a contractual relationship expressed or implied with the contractor, has a right under Arizona's Little Miller Act to assert an action on the bond by giving the following notices. And as set forth in the slide here, you have to give the preliminary 20-day notice, and you have to give the 90-day post-completion notice stating, number one, the amount claimed, and number two, the party for whom the material was supplied or the labor was performed. And this can be somewhat confusing, so I think it's helpful to look at it in terms of a chart. And this is a chart for those who have to give notice under and those who have claim rights under both the Federal Miller Act and Arizona's Little Miller Act. So you see the general contractor at the top is going to be the party who furnishes the bond. the first tier subcontractor and the first tier supplier, they have direct a direct relationship with the general contractor. They have contractual privity. So in theory, the general contractor would know that they're out there and they're expecting to be paid. The folks downstream from the first tier subcontractor, that's the second tier subcontractor and the second tier supplier. Those folks are protected under both the Federal Miller Act and the Little Miller Act, but they have to give notice. So on a federal project, those folks have to give the 90-day post-completion notice, and on an Arizona project that's governed by the Little Miller Act, you'd have to give the preliminary 20-day notice, and you'd have to give the 90-day post-completion notice. And then the folks in red here on the bottom are the folks who would not be protected by the bond. Step 5, know your deadline to file suit to foreclose on the lien or recover against the bond. A claimant must sue to foreclose its lien within 6 months of recording. Like I said before, a foreclosure asks the court to order the sale of the property to satisfy the lien, and the claimants with valid mechanics liens share in the proceeds. If no foreclosure action is filed within 6 months, the lien expires by operation of law. And so one caveat here that I'll mention quickly, because I know we're kind of running long on time, is that the deadline to record a lien is measured in days. So we talked about 120 days after completion in a couple slides. The deadline to sue to foreclose is measured in months, and that distinction can have differences. So can result in differences. So make sure that you're paying attention, you're mindful that with respect to suing to foreclose, 6 months may not exactly be 180 days. And payment bond claims. So you must wait under the Miller Act or Little Miller Act 90 days after the last of the labor or material that you furnished was provided. So you got to give that 90-day notice, but you can't sue to recover on the bond before that notification is provided. And then after that notification is provided, you have 1 year after the date that the claimant last performed labor or supplied materials to sue. And so that's different in the lien world. You have 120 days after anyone furnishes labor or material to record your lien, and then 6 months to sue. In a payment bond situation on a public project, you have a year. You have to wait 90 days, and then you have a year from when you last furnished labor and materials to sue to recover on the bond. So it is a different structure. With that, that concludes our presentation today. I will end with this disclaimer before I turn it back over to Diana, and that is Arizona statutes and case law relating to the construction industry are full of detailed technical and requirements and exceptions, and this presentation can't substitute for legal advice. So if you have a specific situation that you're dealing with, please reach out to a qualified construction attorney and discuss it with them. And with that, I will turn it over to Diana.
Thank you so much, Kevin, for such a wonderful webinar. You provided some really great information. We do have a question. It's about the webinar itself. Will there be copies available of the webinar? The webinar is being recorded and it will be available, the recorded copy. We do not have the actual presentation, but you could see the recorded copy as many times as you wish. It will be uploaded to our website. And there's another question, the one that says, can I collect the entire unpaid amount from the property owner if they have already paid the original contractor in full?
Well, that's an interesting question, and so I assume that in that circumstance, the person that's seeking to be paid is either a subcontractor or supplier, and in that circumstance, the owners paid the general contractor, but that money hasn't made its way down to you as a subcontractor and supplier. And to the extent that you have had, you've protected your lien rights, you haven't waived your lien rights, and you've done all the necessary prerequisites to assert a lien claim, you may be able to recover against the owner for the unpaid the unpaid balance of your contract, or the unpaid amounts owed to you for materials furnished. And so that depends on a couple of things. Number one, your lien waivers, what you signed, and things of that nature. But Arizona law does, in certain circumstances, provide for a situation where an owner may have to pay twice for work. And the way the owner theoretically protects themselves in that situation from having to pay twice for work is to make sure that when they're issuing payment, that they have lien waivers from not only their general contractor, but from the subcontractors and suppliers whose work roll into that payment application that they're paying. And so if an owner didn't do that, and you've complied with the statutory prerequisites to have a lien claim, you may be able to recover.
Great. And the other question is, if I haven't been paid, I have to pay for a lien. Can I get the fees reimbursed for the lien?
So yes, yes, potentially. So if you haven't paid and you have to record a lien, and you have to sue to foreclose, there are a couple of statutory mechanisms to recover attorney's fees. First, as part of any lawsuit to record a lien, depending on where you are in the chain, there may be a direct contractual. There likely is a direct contractual claim, whether it's against, if you're a sub, whether against the general contractor, or if you're the contractor, whether it's against the owner. And so one thing you'd want to look at is the contractual terms to see if they provide for a non-discretionary fee award. If they don't, Arizona has a statute in breach of contract scenarios, ARS 12-34101, that says that a court may award a successful party in a contract action their attorney's fees. That is, however, because the word may is used, that's left to the court's discretion. So there, you may sue and go down that road, and you may get your fees, you may not. But it is a regular practice, I think, for judges to consider 12-34101 in awarding fees. The Arizona lien laws also provide similar statutes. Arizona lien laws provide similar opportunities to recover fees in a discretionary way as well. So there's a couple components of Arizona's mechanic lien statute that say that the courts may award the successful party their fees, and again, it's discretionary. And that's one thing that, when we're going back to the contractual requirements that we talked about at the outset of the presentation, if you have a contract that says that fees shall be awarded, that is a way to take the discretionary component out of a fee award. Now, in that circumstances, courts will still evaluate fees that are applied for reasonableness. But in those circumstances, the party with a fee provision in a contract that says that it's the fees must be awarded, they will remove the discretionary component out, and provided that the prevailing party, they will be awarded, likely will be awarded some portion of their fees.
Great. Well, thank you so much. If anybody thinks of a question that was not addressed, feel free to reach out and we will be sure to answer any questions. Kevin, could you please go to the next slide?
Sure.
All right, we got a pop quiz going on. Who's ready to win a gift? We are testing your knowledge. If you can answer these questions correctly in the chat, we will go ahead and send you a little prize. So here are the questions. When do I need to send an Arizona preliminary 20-day lien notice? A, 20 days from first furnishing. B, 25 days from last furnishing. C, 25 days from first furnishing. D, 30 days from last furnishing. Drum roll is A. Am I right, Kevin?
Yep.
All right.
You can serve it later, but if you want to be protected, A is the best practice for sure.
Right. The next question would be, within how many days from the date of last furnishing materials and or labor, subcontractors or suppliers on state projects in Arizona need to file the claim on the bond? A, 75 days, B, 90 days, C, 60 days, D, 100 days. And I believe it's B.
Yes, it is.
Right.
Yep. If you are not a first tier subcontractor, like we showed in that graph on the slide, you need, if not a first tier subcontractor supplier, you have 90 days in Arizona, and that's provided that you sent the preliminary 20-day notice on the front end.
Perfect. All right, great. We will send you that little prize to who answered. I see some answers there. Go ahead and thank you so much. All right, the next slide, this is for all the resources that you can get from our website. Feel free to scan the barcode or go to sunraynotice.com and you can have all these resources at hand. Very useful and informative. And we do have a new service, is SunRay Receivables. Any collections that you need to do, we're glad to help you with. So feel free to go to sunraycollections.com or email us at getpaid@sunraycollections.com. In our next webinar, very important, we have using lien releases in Arizona, proceed with caution on June 28th at 12 Eastern time. And the next one is what happens after I record my lien, how do I get paid? September 27th at 12 Eastern time as well. You can register at sunraynotice.com/education. Okay, and we'd really appreciate it if you could give us a Google review. Go ahead and scan that barcode. We really truly appreciate your time and your input. Next one. I think that's all for us. Kevin, thank you so very much for your time. Thank you everybody for all your time, and it was a great webinar.